Good evening and welcome to The Clash. This is my colleague and co-anchor Athar Khan. I'm Madhav Das Gopalakrishnan. Today the issue that we're going to be debating is the much-awaited judgment of the apex court in the Ram Temple issue. Won't the Supreme Court at some level or the other have to really uphold its own judgment in 1994? This was by a constitutional bench. It was a well-considered decision that mosques are not integral to the practice of Islam because namaz can be performed anywhere. That's going to be the line on which I'm going to argue. We will of course have several other arguments, but that will be the opening line of argument.
The counter contention is going to be that the court was misled in the Ismail Faruqui judgment in 1994. Mosques are not only integral but essential to the practice of Islam, and in one way or the other, that particular judgment infringes on the right to practice faith under the constitution guaranteed to all citizens of this country. More arguments coming up on The Clash tonight, but time now for the question tonight.
The question that we're debating this evening: does the verdict of the Supreme Court hold the key to Ram Mandir? And this is my submission. The Supreme Court Constitutional Bench in 1994 held the view that mosques are not integral to the practice of Islam. Namaz can be performed anywhere. That's what the Supreme Court of this country itself observed. There is no reason to believe that Supreme Court is going to change the view that it has already expressed in 1994. Secondly, the fact is that the law of the land recognizes a fact of a temple and the real significance of the land on which a temple really has been consecrated. According to the law, masjids are not essential to the practice of Islam, as namaz can happen everywhere. And lastly, there are several Islamic countries like Saudi Arabia, like Egypt, which have raised or demolished mosques for various other reasons, including redevelopment or other developmental projects. So essentially, this issue of raising a mosque is not alien to Islam globally.
Masjid is not an integral part or an essential part of Islamic religion, and masjids can be broken, masjid can be shifted.
राम मंदिर का निर्माण जिस किसी उपाय से हो सकता है, शीघ्र होना चाहिए, ये मेरा
The 1994 judgment of the Supreme Court, otherwise known as the Ismail Faruqui judgment, was wrong. The court was misled. It is absolutely wrong to say that mosques are not essential to the practice of Islam, the faith of Islam. India is a secular country. It is not consistent with Indian secular ideals and Indian secularism to evaluate comparative significance of religious practices to the detriment of other faiths. Lastly, numerous verses in the Quran as also in the Hadith boldly highlight the importance of prayer inside a mosque in a congregation. The 1994 judgment infringes on the right to practice religion. Lastly, very quickly, as Mr. Dhawan, Advocate Rajiv Dhawan had said in his plea to the court, every mosque, temple or church is a place of particular significance. There cannot be any evaporation of the essential practices doctrine. Doctrine is my right to pray at the Babri Masjid not to be respected. Why is there a war in Jerusalem with regard to the Dome of the Rock? Because it is regarded as a part of essential practices.
Masjid Islam के में essential नहीं है. ये गलत ऑब्जर्वेशन है और सुप्रीम कोर्ट के दूसरे जजमेंट के खिलाफ है.
Joining us tonight on The Clash, Ishkaran Bandari, as well as Sudesh Verma from the BJP. From that side, on this side, Dr. T.A. Rahmani, as well as Dr. Faruq Khan on this side. Madhav, you started off.
Dr. Rahmani, let me begin. Is there any reason to believe that the Supreme Court will revisit and change the judgment that it has given in 1994? It is a constitutional bench of the Supreme Court that has heard this and has arrived at this particular principle. Is there any reason to believe it will change?
I don't think there is any reason to believe such a thing, and it is becoming highly speculative or highly to think those things which goes into our own favor and suitability. It's like that. This case is very simple. The bench is to decide whether it can be heard, it shall be heard at a larger constitutional bench or not. It was a 3-judge bench earlier, now it is prayed that it shall be a 5-judge bench. And the court has only to decide whether it has to be heard by a larger constitutional bench or not. That's it. Not more than that. That's why it's not that important that as if the hell will broken on the earth if some decision comes tomorrow. It is highly a political motivation just to keep a Babri Masjid and a Mandir issue alive. Nothing more than that. It's not sensational. Don't sensationalize it, please.
Okay, time is up. Let me go ask Sudesh Verma my first question. Justice Suma Pal, Sudesh, as a judge of the Calcutta High Court, had observed that the Tandava dance is an integral part of the religion of the followers of Anand Marg. This is against the police versus Acharya Jagdishwarananda 1990. Subsequently, the Supreme Court in 2004 affirmed it. How is that different?
You see, we don't believe that the form of religion can be an integral part of religion. Religion is something intrinsic. In 24 years, Madhav, how is it possible that the form of Islam will change? That when it was supposed that Masjid is not a part of Islam, now Masjid can become a part of Islam. What is the new argument? We don't understand. But the larger issue is, why this issue is being debated is in the context of the likely judgment on the dispute, Babri structure, Ram Janmabhoomi temple. It's a fact that namaz was not offered there. It's a fact that an invader came and constructed that mosque, demolishing the Ram temple that exists there. It's a fact that Ayodhya happens to be birthplace of Ram. It's a fact that after excavation it has been proved that temple existed. There is a fact that Allahabad High Court has given a judgment, trifurcation of the land. So what is that the Supreme Court is listening to? Is the land dispute, they said finally, and now they're talking of different issue that is going to deflect the entire issue.
All right. Faruq Khan, the question is this, and I just want to quickly quote from the 1994 Ismail Faruqui case, and this specifically says, a mosque is not an essential part of the practice of the religion of Islam, and namaz or prayer by Muslims can be offered anywhere, even in the open. Accordingly, its acquisition is not prohibited by the provisions in the Constitution of India. When the Supreme Court has so explicitly said this, can there be really any change as far as Supreme Court, or even does this matter need to be heard by a larger bench?
Yes, of course. See, I'm no expert of Islamic law. I will frame my arguments under the constitutional framework. Now, we have three judgments I will cite which goes contrary to the law laid down in Ismail Faruqi. That is one, Shirur Mat Venkat Rama Devaru case 1958, Dargah Committee case 1961, three-judge court ruling in Shri Adi Vishweshwara of Kashi Vishwanath Temple versus the state of UP and others 1997. Now, the question is that whether analysis of comparative significance of religion is permissible within the purview of Article 15, 25, 26 in harmonization with Article 14 of Indian Constitution. Now the point is that Ismail Faruqi case, in my personal opinion, needs to be revisited by the Supreme Court. Again, it is needed, it is dire need, because certain observations are being made which goes contrary to the Supreme Court ruling itself.
Okay. My contention, Ishkaran, is this, and this is the contention of the lawyer, Mr. Dhawan, who has in fact filed the plea with the court back then as well, that comparative significance between the Babri Masjid as any other mosque that Muslims might or might not have prayed it and Ram Janmabhoomi is inherently inimical to Indian secularism.
See, firstly, let's get one point clear. Faruqi was a 5-judge bench, not a 3-judge bench. And this bench will only be going into the fact whether a 7-judge bench or a 9-judge bench should be done or not be done. The other point is there is no comparison here. That judgment said mosque is not an integral part of Islam. It wasn't saying versus Ram Janmabhoomi or versus Krishna Janmabhoomi or any such thing. It was squarely on the part whether mosque is essential and integral to get constitutional provisions which some minorities get under the constitutional scheme, or would it not get by not being an essential part. The court ruled it's not an essential part. For that, the court ruled and saw other Islamic countries also, including Saudi Arabia, where there is a New York Times article which said mosques which are ancient and holy, one of the mosques which the article quotes where even Prophet Muhammad himself used to offer namaz, has been shifted and a 5-star has been built to put pilgrims there. Palaces have been built by the rulers of Saudi Arabia. So when in holy city of Mecca, you can shift mosques, why can't you do it in India?
Okay, I think that question needs to be answered by Mr. Rahmani. When this can happen in the in Mecca, in Saudi Arabia, or in Medina, why can't this be done in India? Because clearly there is a precedent, and the entire concept of a mosque does not seem to be essential to Islam if these are to be believed, if these instances in Saudi Arabia are to be believed.
You see, number one, those mosques were not disputed, not under the scrutiny of any court, which has been demolished. Number one. The Babri Masjid, we are talking about the Babri Masjid. Babri Masjid is a disputed place which court is hearing, number one. And number two, the Saudi government or the Turkish government or any other Muslim government cannot become a precedent for India. We are not going to adopt their laws in the country.
Absolutely.
If you want to adopt the country, then go and sansar kijiye phir rapist ko. You have to cut the fingers of a thief. If you want to adopt, so why do you quote those foreign countries for the Indian context? Our constitution is quite different from that of so many other countries. So why shall we adopt all those things? And as far as Islam is concerned, even the Islam, it is very, very clear. All these scriptures of Islamic book.
Okay, your time is up, sir.
Let's have a response. You made some points, but
again and again it's being said, this judgment is not saying that because there is a dispute going on in Babri Masjid, that whether mosque is essential part of Islam or not. It's a holistic judgment which says mosque per se is not essential part of Islam. That was on a constitutional principle, was not on this land dispute. I'm talking about Faruqi. That observation is a constitutional scheme observation by the, or judgment, not even observation, by the Supreme Court, that is not restricted only to Ram Janambhoomi dispute.
And if I just I wanted to respond to this. I'm just reading from that very judgment. This judgment specifies what this case is about. Because it says if that is the position in law, there can be no reason to hold that a mosque has unique status or special status higher than that of places of worship of other religions in secular India to make it immune from acquisition by exercise of the sovereign or prerogative power of the state. So there's no immunity from the acquisition of a mosque. It's on a simple aspect of the
it was raised by a mob.
Sir, it is not a communal issue to my viewpoint. It is not a matter of Mandir or Masjid.
No, but you are raising Ram Mandir.
No,
because you said
this because you are quoting it. As far as my opinion is concerned, this is simply a title suit. The Supreme Court of India has to decide to whom this land used to belong.
Okay, I have a question for you. Very quickly, I have a question for you. Are you suggesting that based on the Ismail Faruqi judgment, that a particular practice in one particular faith is comparatively more or less significant than the other? That's question number one. And let me just point out, sir, the government did not acquire the land. It was raised, the mosque was raised, or the erstwhile mosque was raised by a mob, not the government.
Yes.
You see, my whole contention is that the brigade that tries to derail the judgment on Ayodhya, they have succeeded by raising the issue. This issue was not there at all. Coming to Mr. Ramani, it's a very sensitive issue you have raised, and because you have raised, I am going to comment, and I know it's going to create controversy. You see, the whole point is, as I understand, correct me if I am wrong, Mecca stands to be your Punya Bhumi, where you look, holy place, religious place. So naturally, you look forward to Saudi Arabia or to countries to get those Islamic practices which you may not be practicing here. So now, the issue is that in that context, it was quoted that if it can be shifted there, they say that they are more practicing Islam. But if you say that if we have an Indian version of Islam, then we welcome you, because this is what we have been saying all the time. If you have that, if you are saying that, can I complete? Ramaniji, let me complete. This is what we have been saying. This is what we have been saying, that Lord Ram is your Purvaj. Because you belong to this country, you are also a Hindu. You have just adopted a different practice.
I'm not.
So there's no problem. So why should you oppose construction of Ram? Tell me that.
I respect Lord Ram.
If you have, or you accept it, that forces you.
Because 100 that doesn't mean that I am a Hindu.
But you are a Hindu.
No, I'm not. Please, how can you say who am I? You cannot tell me who am I.
Do not respond. You are a Hindu, no? Don't respond.
One second.
Don't respond, sir. Please do not respond.
That is a
Dr. Rahmani, do not respond to that. Dr. Farooq Khan, first of all, he contradicted himself. They are big critics of Wahhabi Islam, and then he says that, look, you look towards Saudi Arabia. That's obviously a contrarian statement. But on the subject of what he said right now, and my point, which he did not answer, was that this was not acquired by the government. It was raised by a mob.
They cannot, no law, no activity can justify what went on 6 December 1992. That's a big shame for all of us, for an Indian democracy. Now this debate should be confined to the legal and constitutional issues. We should not travel beyond with the religion, and we take the disguise of religious arguments to prove our case. Rather, it will only like this place. Then we will be also, then we are also bound, you know what we will do. We will start throwing mark on each other. other. The point is that it's a constructive arguments being made, and as far as the Faruqui judgment is concerned, if Faruqui judgment has to be taken into applicability in its entirety, that is going to create wider ramification, not only for Muslims, also for Hindus. So we have to make sure that the fundamental rights being provided by our great constitution, as enshrined therein, has to be protected both for all communities, all religion, whether it is Islam, whether it is Hinduism, it is Sikhism, Jainism, everyone.
Okay.
So that's the point.
Quick response. First, one point here. Let us repeat again that this demand that it be referred and be revisited was made by the Council for Muslim Parties. That was a part of strategy. Mr. Kapil Sibal also argued that the matter be heard after 2019. So the strategy was very clear to delay a judgment. I think we all have to move expeditiously to a judgment. It was a legal strategy to delay judgment by raising an issue which need not be raised. But now that it has been raised, let's not confuse the issue. Nobody is saying whether mob violence...
Let him finish his point, sir, please.
Nobody is making a case whether mob violence can destroy any building. That's not the point. Point is whether the government has the power to take it over. If it is an essential part, then even government will not have power to take it over. That is what the court ruled, that it is not an essential part and government can take it over.
Okay.
Mob violence is a completely separate...
Let's not. We are discussing tomorrow's case. Yes, let's not go beyond the brief of tomorrow's case. I just request all our panelists.
30 seconds. The land was acquired, and that was a Waqf land. It was a very clear. Every record show that the Babri Masjid was a Waqf land, and nobody can acquire that. It has been wrongly acquired. Then during this 1994 Ismail Faruqi case, we could not present our case to that bench. That's why we have referred, because it's not just the essentiality or integrality of the mosque or not. It can open the Pandora box for Hindus, for Christians, for Sikhs, every place of worship. So, and both the cases are different. But because it has been attached with the Babri Masjid case, that's why the Muslim parties has raised this issue that this must be clarified and our stand must be heard more specifically.
I want to Mr.
Not
if
more
it
than
was a
that.
title dispute only, this need not have been raised by the Muslim parties right now. It was only a title dispute, but it is not a title dispute because there are additional factors in this case. That is why it's going there. So you can't take both the sides. That it's a title dispute, whereas this also should be revisited.
The Supreme Court of India has declared that they will take it as a title suit only.
So then this will not be revisited.
30 seconds to you, please.
Athar, the issue is also whether, because we are talking in the context of Babri Masjid, it's not out of the context, whether Babri's structure was a mosque. That itself is a question which Muslim scholars have given different view. Namaz was not being offered there. It cannot be a masjid, because you offer namaz even on the street. There is no masjid there. So that integrality one can always question. So now the issue is, as you rightly said, it's a legal issue. The court said first there is a legal issue, we'll get into this land dispute. Suddenly this religious angle is coming. So even if, for example, masjid is an integral part of Islam, is that going to impinge on the judgment of Babri?
Okay, let him answer. Let him answer.
Going by your logic, Kar mein Bhagwan basta hai.
Exactly.
Then we don't need even any temple, any mosque.
No,
please, I have not interrupted. See, now Lord Ram is a revered personality. Please don't demean him by dragging him to the petty politics. Now the point is, if our politicians would have been serious on this topic, on this subject, it would have been resolved years ago. But they want this issue to burn so that appropriate political mileage at appropriate time could be accomplished. That's the point. Now the point is that if we have a comparative submission of Faruqi judgment, ratio of judgment will apply not only to Muslims. It will also apply to Hindu.
Yep.
It will apply to every religion. Going by that logic, then we don't need it.
Do we want that?
That's the point.
Will it really apply to religions? Because is that really an equivalence that can be drawn?
Every sect or denomination, leave religion, will have to come forward and argue what is essential practice. Leave religion, even denominations have the right to argue that we have essential practice and then it gets protected. So that is not a factually correct statement, nor a legally correct statement. Second point in this case is, as I again repeat, this demand for revisiting has been raised by Muslim parties. It has not been raised in the court by Hindu parties or parties seeking Ram Mandir there. So when it has been raised by Muslim parties themselves, you cannot come here and then again say that it's merely a title dispute. Please make your mind clear. Is it a larger issue or is it only a title dispute in your mind yourself?
30 seconds.
You have to have
30 seconds.
Can I counter what he said? Because he said very objectively.
This issue was raised because this has been referred by the court. Otherwise, the Muslim parties, even after 1994 to this 2013, that was not being raised because this was tried. The Supreme Court's submission observations were affecting. Quoting this case, that's why this issue has been raised. It was a 5-judge bench, and we were not heard clearly. It was effective.
Supreme Court has not given any observation.
I take very strong exception to what my colleague said, my fellow panelist said. राम कनकन में बसता है तो मंदिर की जरूरत नहीं है.
No, that was not. Please don't put your words in my mouth. You ask such questions. Lord Ram is very revered to me as well.
You said कनकन में बसता है ना, so you don't need a mandir there. You don't need a mandir there. So you don't need a mandir there.
Okay. You don't need a mandir there. Let Supreme Court decide. Let Supreme Court decide.
People are what you say. No, let me complete my. Let me complete my submission. Let me complete. No. Let me complete. I heard what he said. Mr. Rahmani. You did not speak. I was listening to him. I did not counter you. The whole point is, Ram Kankan mein basta hai. You can take liberty with Ram. You can take liberty with Shiv. Doesn't matter. We as Hindus, we are very tolerant. We accept everything. But can you say the same about Masjid? Wahan kaun basta hai?
All right.
Good,
very good. Now I raised my argument from your point. That if
the road has argument from my point, I can argue. I don't need you to argue.
Okay, no cross debate. Please
bear with me. All I'm saying that Faruqui case, if it is not revisited, will have serious implication on all religion. It will compromise the constitutional guarantees being available to all citizens irrespective of the religion.
No, the point is the judgment basically just says that all religions are equal. That there is nothing. It is not that Muslims are more equal than others.
That is there for 25 years.
Okay, let me. I want to come back to the issue at hand.
Yesterday and are saying it's going to have serious consequences. It has been there for 25 years.
No selective reading. Okay.
What are serious 25 years?
Consequences? Are you waiting
but there are no consequences for 25 years. What bigger proof can there be?
That's why
that
Dr.
there are no consequences?
Okay. What is essentially
no consequences?
Dr. Rahmani,
and today you have opened
Dr. Rahmani, just listen to me now. I want to just ask you a direct question, because when we raise the context of Saudi Arabia, you said that why are we following jurisprudence of Saudi Arabia? Point well taken. Now I am reading out scholars in India. This is what Dr. Farida Khanam, chairperson of CPS International Center for Peace and Spirituality, has said, and I am quoting her. Now she says only 3 mosques, namely the ones in Mecca, Medina and Al-Aqsa Mosque, are considered sacred in Islam. So there is no need to argue on this point. Mosques can be moved as per the requirement maybe, but with full respect and responsibility. The question is this, that there are several Islamic scholars, I can read out several others also if you want to, who actually are coming out and saying this, that so it is not just the jurisprudence of Saudi Arabia. There is a strong view within the Islamic community itself that this entire aspect of a mosque being shifted is not such a controversial point. That is as is being raised.
I replied you already. You see, in Gujarat, so many mosques has been transferred from one place to other place. In Gujarat, after 2002 itself, I can give you the list of 100 mosques, and nobody objected to it. And I said at the very beginning of this program that those were not the mosque under dispute or under the court scrutiny. This point must be taken because the court has to take a decision whether that land belongs to the mosque or not.
It is about
whether it belongs to the or it belongs to Allah. That has to be taken.
It is not area where a mosque by mosque principle. It's a constitutional principle.
We cannot change.
Okay, let him respond.
If at all,
let him respond.
The judgment goes in favor of mosque.
You made an important point. Okay, now let him respond.
Are we going to?
Okay, Mr. Rahmani, please. You made a point. Now let him
Please let your audiences know constitutional principles will not be different for Gujarat or Babri Masjid. It's a constitutional question
not?
whether mosque is essential part of Islam or not. That's a constitutional principle. Will not be mosque by mosque, area by area, dispute by dispute.
Yes.
It will be pan-India principle.
That
is the basic law.
I want to remind you.
Hold on, sir. Let him answer.
Basic law.
He's made a legal point.
So VP Singh का कानून में बताना चाहता था.
ठीक है, sir. ठीक है.
जिसमें
Sir, Gujarat में essential part of religion है.
I will request my learned friend to kindly read Shri Adi Vishveshwara of Kashi Vishnath Temple, was the state of UP, 1997 judgment of Supreme Court. It will answer it. Now, the problem is that this being a title suit, we have a two different component. We have to appreciate this. Now, this being a title suit, but there are certain constitutional issues, the constitutional guarantees, and if one is asking to revisit, let us leave this. We can't go on a speculative journey. Let us leave this to the finest wisdom of Supreme Court, which will deal with this matter tomorrow.
Fair enough.
This
fair
is
enough. We're out of time.
To be done or not.
We're out of time on this. We're out of time on this. I must thank all my guests: Sudesh Verma, T. Remani, Ishwaran Bandari, as well as Farooq Khan. That's Madhadas Gopalakrishnan. I am Atar Khan. Watch us again tomorrow on The Clash, same time.
Thank you so much for joining us this evening.